Good afternoon, everyone. Myself, Dr. Ashish Khatod, and Medicolegal Advisor, Rapid Medicolegal Services India Limited. Today, I am going to talk on updates related to medical field in BNS 2024. Now, every one of us knows that from 1st July 2024, the Indian Penal Code get replaced by the Bharatiya Nyaya Sanhita. Code of Criminal Procedure get replaced by the Bharatiya Nagrik Suraksha Sanhita. And the Indian Evidence Act get replaced by the Bharatiya Sakshi Adhiniyam. So these laws are applicable to every citizen of India, but there is a certain category of persons who are immune from the proceedings under the criminal law. So these persons are president of the country, means president of the India, governor of his state, foreign sovereign means the head of the foreign country who is visiting India in his official capacity. Again, foreign diplomats, foreign ambassadors means who are the agents of the head of the foreign country. So the foreign diplomats, ambassadors, and the consuls are considered as the representative of the head of the foreign country. So you can see that doctors are not in this list. Means these criminal laws are applicable to the doctor as that of ordinary citizen. So now I will tell about the territorial jurisdictions. Means these criminal laws are applicable within the territory of India, including the state of Jammu and Kashmir. Again, any ship, vessel, or aeroplane of any country which is within the territory of India, ship, vessel, or plane which is registered in India, wherever it may be. So these laws will be applicable to any aeroplane or vessel or ship, wherever it may be, if it is registered in our country. So what happened? This plane, vessel, or ship which is registered in India is considered as a territory of India because it has an Indian flag. Citizen of India, wherever he may be, for the offense committed anywhere. So any citizen of India, wherever he is, this criminal laws will be applicable to him. Again, citizen of any country who is within the territorial jurisdiction of India for the offense committed in the territorial jurisdiction of India. Why I am telling this? Because many times we hear that any doctor saved the life of the patient during the aeroplane during the emergency. So in one lecture, one doctor asked me this question: Can he be tried for the treatment given in the aeroplane? So the answer is yes. In the following situation, the doctor will be liable for the treatment given in the aeroplane for the medical negligence committed during that treatment. Again, the most important thing is definition of RMP is prescribed in the criminal law. So according to this criminal law, this definition is prescribed under the section 106 subsection 1 of the BNS, Bharatiya Nyaya Sanhita, during the offense of death, for the offense of death due to negligence. Again, the definition is prescribed in section 51 of the Bharatiya Nagrik Suraksha Sanhita, which is for the medical examination of the accused. Again, section 184 of the Bharatiya Nagrik Suraksha Sanhita during the medical examination of the rape victim. So according to this, all these three sections, a medical practitioner possessing any qualification recognized under the National Medical Commission Act 2019 and whose name has been entered in national or state medical register maintained in accordance with this act will be considered as a registered medical practitioner. Means any doctor possessing any qualification other than the MBBS, means a non-MBBS doctor is not considered as a registered medical practitioner according to these criminal laws. And why this is important? Because there is a difference in the punishment for a death due to negligence by a registered medical practitioner and by any other person. And again, during the medical examination of accused and the medical examination of the rape victim, if the medical examination is done by the non-MBBS doctor, then the defense lawyer can claim that this is not done by the registered medical practitioner. So first, most important thing is death due to negligence. So provision of the death due to negligence. So during the IPC, in the IPC, death due to negligence, the offense of death due to negligence is prescribed under the section 304A of the IPC. And in that section, the punishment for the death due to negligence was or fine or with both. And now the punishment for the death due to negligence is prescribed in the BNS under section 106. So according to the subsection 1 of this section, the death for punishment for the death due to negligence is enhanced from 2 years to 5 years, and shall also be liable. The accused shall also be liable to the fine. But at the same time, there is a one proviso that if such act is done by a registered medical practitioner while performing medical procedure, he shall be punished with imprisonment of either description for a term which may extend to 2 years and shall also be liable to fine. Means for a death due to medical negligence by a registered medical practitioner, the term of the punishment was kept same as that of IPC, that is 2 years. And in the explanation section, the definition of the registered medical practitioner is given, which I have already told you. So now for better understanding, we will compare this section in a chart. So this is a chart where in this where this is a section 304A of IPC, which is for causing death by rash or negligent act, and for which the punishment is imprisonment for 2 years or fine or both. And this is section 106 subsection 1 of BNS, in which there is a causing death by negligence, that is imprisonment for 5 years and fine. And at the same time, causing death by negligence by RMP, the punishment is imprisonment for 2 years and fine. So though the death due to negligence by RMP, the term of imprisonment is kept same, but the severity of the offense is increased, because in the IPC the word or is used, while in the BNS the word and is used. Means in the IPC the punishment imprisonment in the punishment imprisonment was optional. It is upon the discretion of the magistrate whether to give imprisonment or to give fine only or to give both. But now in BNS the imprisonment is mandatory. So both in both the acts, offense is cognizable, bailable and triable by the magistrate. So this is a copy of circular which I have issued on 1st January 2024. So for the medical negligence, can offense be registered under sections other than the section 106 subsection 1 of the BNS 2023? So unfortunately the answer is yes. Though it may result in passing of the FIR or acquittal of the doctor, but the offense can be registered. Some of these sections are section 103 subsection 1, which is for murder, which is cognizable offense, non-bailable offense, and triable by the court of session. Cognizable offense means such offense where police officer can register FIR without the order of court. Means police officer can take cognizance of the offense and can arrest the accused without the order of the court, without the warrant. At the same time, the offense is non-bailable. Non-bailable offense means where the accused cannot claim the bail as a matter of right, while the bailable section is the section where accused can claim as his right. Means in non-bailable section, it is upon the discretion of the court whether to grant the bail or not. Another section is section 105, which is for culpable homicide, which is cognizable offense, non-bailable offense, and again triable by the court of session. Some other sections are section 117 subsection 2, which is for grievous hurt, which is cognizable offense, but it is a bailable offense, means less severe and triable by the court of magistrate. When the offense is triable by the court of session, it is more serious, and when the offense is triable by the magistrate court, it is less serious. So these all offenses were also present in the IPC also, but with a different section number. So this section number 117 subsection 3, which I have shown in the red ink. So this is a new provision in the BNS. It was not present in the IPC. This is the offense of grievous hurt resulting in permanent disability or vegetative state. This new offense is introduced in the BNS, and this offense is introduced by keeping in the mind the victims of the acid attack. But this offense can be misused against the doctor. How? So suppose there is any case of convulsion or myocardial infarction or any other emergency, and during resuscitation there is a hypoxic brain injury, and the patient, due to which patient went into the permanent vegetative state or permanent disability. So in such situation, the relatives of the patient can claim that this happened due to the delay in the or negligence in the resuscitation or in the treatment. This is cognizable offense, non-bailable offense, and again triable by the court of session. Means this is a serious offense. there is one more section like 271, which is for negligent act likely to spread life-threatening infection. This is cognizable offense, bailable offense, and triable by the magistrate. Means this is not much serious. This is section 272, which is malignant act likely to spread life-threatening infection. This is also cognizable but bailable offense, triable by the magistrate. These two offenses were also present in the IPC also, and were widely registered against the many people for spreading the infection of the COVID-19. These sections were imposed against the general public also. This is 316 subsection 2, which is for criminal breach of trust. This is non-bailable offense and triable by the magistrate. And again, there is a section 318 subsection 2, which is for cheating. This is non-cognizable offense, bailable offense, and triable by the magistrate. So these two types of offense can be registered in case of when there is a suppose there is a cheating of the patient, or if some doctor pretends that he's a specialist in some field and actually he's not a specialist in that field and treat that patient, then the patient can register the offense against doctor that doctor has committed criminal breach of trust, means he breached the trust of the patient or cheated the patient. So these are offenses which can be used against the doctor. So this section 317 18 subsection 2 for the cheating in the IPC, this was prescribed in the section 420, and now the definition of the cheating, there are some changes in the definition of the offense, and now this part which can again of the offense which can be used against doctor is made non-cognizable and available and triable by the magistrate. So, most important factor is for the death of any patient, offense can be registered under the sections. Either the offense can be registered under section 106, subsection 1, which is death due to negligence. This, as we saw earlier, this is a cognizable offense, bailable offense, and triable by the magistrate court. And in such type of offense, there is a immediate bail by the JMFC. JMFC means Judicial Magistrate of First Class, which is a lower court present at the Tahsil level. So, in such cases, what happen if the doctor is arrested and presented before the court will grant the bail doctor immediately. Police officer cannot pick the doctor from any place, or cannot keep the doctor in the police station or behind bar during the night. Police officer has to investigate the offense during the day only. So this offense is not much serious. So nothing to worry about it if offense is registered under subsection 106 subsection 1. But okay, exceptionally, the offense can be registered under the sections of section 104, which is for culpable homicide, and or against the under the section 103, which is for murder. So what happened? This is also cognizable offense, but this is non-bailable offense, triable by the court of session and punishable with imprisonment of more than 10 years. So due to this punishment of more than 10 years of imprisonment, what happened? As offense is non-bailable, but due to this punishment of more than 10 years, session court doesn't grant bail till the submission of the charge sheet, and for the submission of the charge sheet, time limit is prescribed as 90 days. So if offense is registered under such in any of these two sections, session court doesn't grant bail till 90 days. This is the important thing. What happen? Either offense will be registered under the bailable section, where the accused doctor can be released on bail immediately after the arrest, or once arrested, if offense is registered under any of these two sections, then once arrested, doctor may have to remain behind bar for 90 days. Otherwise, he have to apply for the High Court for the bail. So, though generally offense is registered under the section 106 subsection 1, but there are the sporadic incidences where offense is registered under the section 105 or 103 subsection 1, murder or culpable homicide. So, this is a case which I came across last month, where in Amravati district, offense of culpable homicide was registered against the lady doctor. So there are some cases. 2 years ago, one offense under the section 302 and 304 was registered against the doctor in Satara. Before that, there was a offense was registered under section 304 against the doctor in Ratnagiri, and the well-known case of Dr. Archana Sharma from Rajasthan, who in this case, what happened? Police registered the offense under 302. she couldn't bear the mental pressure and committed suicide. But now there are some prerequisites for the registration of FIR in case of medical negligence. So first is in one case, Jacob Matthew versus State of Punjab, the Supreme Court of India prescribed that the police officer should take a mandatory expert committee opinion before the registration of FIR against the doctor. But at the same time, Supreme Court said that this opinion is not binding on the police and it is upon the discretion of the police whether and under which section FIR to be registered. So police officer can register FIR in spite of favorable expert or committee uh, opinion with by stating reasons. Public Health Department of Maharashtra government had issued two circulars in the furtherance of this judgment. So in Maharashtra, at least now this is a common practice that FIR is not registered before taking the expert committee opinion. Again, there is a one more judgment which is Lalita Kumari versus State of VP. In this judgment, Supreme Court prescribes that there should be a time of 7 days preliminary inquiry. Means police should conduct that in 7 in cases of offense of allegation of medical negligence. National Medical Commission issued one of this judgment. So, for violation of these provisions, police officer can be tried under Section 198 of BNS. But this is a non-cognizable offense, and for such trial, permission of the government is required under Section 218 of the BNSS. So, no government gives permission to try its employee. So, practically, this offense is this provision is useless. Means if police officer registered the FIR and violates the provisions of these provisions of the Supreme Court, we can do nothing against that police officer. There is a one section about which many doctors are worrying, that there is a one provision in the BNS in section 397 of BNSS that any private or government medical practitioner has to provide mandatory first aid and to inform the police about the victims of the rape, acid attack, and offense under the POSCO Act. Means any patient, if a doctor knows that came to know that this patient is a victim of rape or acid attack or offense under the POSCO Act, then that doctor is bound to provide first aid and is bound to inform the police about this case. He may be private doctor or he may be government doctor. This is binding on the private doctor also. And for the violation of this provision, there is a punishment in BNS under section 200, which is imprisonment for up to 1 year or fine or both. This is a non-cognizable offense, bailable offense, and triable by the magistrate. Means this offense is not so serious, so nothing to worry about it. And these provisions were also present in the IPC and CRPC also, and with different section number. They are exactly copy pasted from here from the old criminal laws. So, is everything bad in the IPC for doctor or criminal laws for doctors? No, there are some good things also. So these things are called as general exceptions. These are prescribed from section 14 to 44 of the BNS. These were present in the IPC also from section 76 to 106. So this can be used as a can be used for defending allegation of medical negligence. So before going to see this, first we have to understand what are the general exception, or what is the general exception means. So for the constituting offense, two components are required. First is intention to commit the offense, and second is action of commission of that offense. So what is general exception? General exceptions is the offense minus intention. Means this is only an action of commission of offense without intention to commit it. The action without intention to commit the offense are the general exceptions. So out of the general exception, I have picked some general exceptions which can be used as a for defending the allegation of medical negligence. So under section 18, it is prescribed that accident in doing lawful act is not the offense. So suppose we are giving any injection or any drug or any dose, and there is anaphylaxis reaction or cardiorespiratory arrest due to that. So we can claim that this happened due to the accident. What we have to prove that we have taken every care to avoid that accident. We have given test dose, we have given that slowly, and that drug and injecting or giving that drug is a lawful, and whatever. And again, after anaphylaxis or cardiorespiratory arrest, you have done everything to save the life of the patient. Again, in the section under section 19, it is prescribed that act likely to cause harm, but done without criminal intent and to prevent other harm is not the offense. Its example is suppose amputation to prevent the spread of the gangrene. We can claim the defense under this section in such situation. In the absence of this depends what would have happened. Suppose there is an amputation to any doctor who does the amputation to prevent the spread of gangrene can be tried under the section 117 subsection 3 of the BNS, means causing permanent disability. This is under section 25. It is prescribed that act not intended at not and not known to be likely to cause death or grievous hurt done with consent, means any treatment given after taking proper consent cannot be considered as the offense under this section. So whenever there is any death of the patient, and then we can claim that that whatever we have done or treated patient, our intention is, and we don't know, and our intention is not to cause the death of the patient, and we don't have the knowledge that the patient this will cause grievous hurt to the patient, and we have to inform the patient everything and taken informed consent. So the importance of consent is implied in this section. This is section 26, which says that act to cause death done in good faith for person's benefit is not the offense. Its example is surgery likely to cause death done by a surgeon with an intention not to cause death but to cure the disease. So, when these criminal laws were passed, there was a rumor that under this section 26, the offense of medical negligence has been decriminalized. But this is not the new provision. This provision was also present in the IPC and under the section 88. The only section number has been changed. Otherwise, everything in the section is same. And this example is also given in the IPC also and BNS. The example is also same. This is section number 30, which says that act done in good faith for the benefit of a person without consent is not the offense. So any treatment given in the emergency like convulsion, MI without consent is not the offense. So every one of us knows that no consent is required in the emergency. But from where this concept arisen? So this concept is arisen from this provision. Again, section 31 says that communication made in good faith is not the offense. Suppose there is a death of a patient due to shock or suicide, in furtherance of the communication made by a doctor that he is suffering from life-threatening disease like HIV or cancer. So, in the absence of this general defense, what would have happened? The relatives can say that the doctor has abated the patient's suicide, means the offense of abatement of suicide can be registered against the doctor. So there is one thing, the consent. Consent is also described in the IPC, BNS. It is described under the section 28 of the BNS. There is the definition of consent has been prescribed at one more place. It is under the section 11 to 22 of the Indian Contract Act. So I am comparing both the definitions here. So according to the section 28 of the BNS, the consent is not valid if it is given under the fear of injury, given under the misconception of facts, and the person taking consent has a knowledge of existence of such fear or misconception, or the consent given by a person who is of unsound mind or who is under the intoxication or who is less than 12 years of age. So this consent is not valid, and except this all consents are valid. So according to the section 11 to 22 of the Indian Contract Act, the consent is not free if it is given under the fear of coercion or undue influence, so which has the same meaning as that of injury, or which is given under the fraud, misrepresentation or mistake. So these three has the same meaning, that of misconception of fact, and given by a person who is of unsound mind, disqualified from contracting. Disqualified from contracting means any person who is adjudicated as insolvent is considered as disqualified from contracting, and who is a minor according to that age of majority. So according to the age of majority, person below the age of 18 years is considered as the minor. So everything is same. The only difference is the age. So according to the BNS, the consent of a person who is less than 12 years of age is considered as invalid, whereas according to the Indian Contract Act, the person who is less than 18 years of the age is considered as the invalid. So in this situation, we have to use one principle of jurisprudence which says that where there is a conflict between the provisions of the special law and the provisions of the general law, then the provisions of the special law will prevail. So in this situation, the BNS is the general law and the Indian Contract Act is a special law. So the provisions of the Indian Contract Act will prevail, and the consent given by a person who is less than 18 years of the age will be considered as a invalid. So after seeing the actions which can be taken by patient against us, we will see the actions which we can take against the patient in certain situations. So for counter case against the patient or the relatives for violence, there is a one special act which is called as the Maharashtra Medicare Service Person and Medicare Service Institution Prevention of Violence and Damage or Loss to the Properties Act 2010. So according to this section, in section 2, the definition of the violence against the medical professional has been described, and in this subsection I of the section 2, in the definition of the violence, intimidation is included. Means intimidating any medical practitioner is also considered as the violence against medical practitioner. Uh, According to section 3, the violence against the medical practitioner is prohibited, and according to section 4, the violence is punishable with imprisonment up to 3 years, and section 5 says that offense is cognizable, means a police officer can register FIR. Non-bailable means accused patient or patient's relative cannot claim bail as a matter of right. It will be upon the discretion of the court whether to grant bail or not, and it is triable by the court of magistrate. So whenever there is a violence against medical practitioner, we have to insist police that the section 3 and section 4 of this act should be imposed on the accused. And apart from this, there are the certain sections of the BNS which can be used against the patients or relative. These are section 109, which is for attempt to commit murder. This is a cognizable offense, non-bailable offense, and triable by the court of session. And for this offense, the punishment of imprisonment more than 10 years has been prescribed. So if offense is registered under this section against the patient or relative, the relative or that patient cannot get bail for 90 days. One more section is section 119, which is for attempt to commit culpable homicide, which is cognizable offense, non-bailable offense, and triable by session. But in this offense, the punishment was 3 years. Means accused can get bail before the completion of 90 days of registration of FIR. Section 117, subsection 2 of grievous hurt, this section can be imposed against the relatives also, which is cognizable offense, bailable offense, triable by the court of magistrate. This is most important offense. This is the offense of extortion, which is cognizable offense, means FIR can be registered, non-bailable offense, and triable by the magistrate. So generally what happens whenever there is a death of the patient, the relatives makes the allegation of medical death due to medical negligence, your negligence or your fault, and says that demand for the money, and says that if you don't give the money, we will file a police case against you. So actually, see, whenever there is a death due to medical death due to death of the patient, it is a right of the patient to file the police case, but they can't directly demand the money. If they demand the money, it comes under the offense of extortion. And whenever such thing happen, if before patient goes to the police station for complaining medical negligence, we should go to the police station and file a complaint of extortion. There are 3 to 4 cases, such cases, which which came to rapid, and in such cases we insisted doctor and convinced doctor do it accordingly. And what happened when the patient got the knowledge that doctor went again to the police station and registered a complaint against us, the patient didn't went to the police station and didn't file any complaint. This is a section 351 subsection 2, which is for criminal intimidation, which is a non-cognizable offense, bailable offense, and triable by the magistrates. So see the difference here. under the BNS, the offense of intimidation is non-cognizable, bailable and triable by the magistrate. बरोबर आहे. But at the same time, this intimidation is included in the violence against the medical professional, and this is a cognizable, non-bailable and triable by the magistrate offense. Means if there is a incidence of intimidation against you, if you goes to the police station and files the case under the BNS only, the police officer will not register the FIR. But we insist the police station to register the FIR against that under the section 3 and 4 of the that Violence Against Medical Practitioner Act. The offense will be become cognizable and non-bailable. This is a case of offense of defamation, which is prescribed under section 356 of the BNS. See, this is a non-cognizable offense. Means in case of defamation, whenever there is a defamation by patient and we go to the police station and says that please register FIR against this patient or this relatives for defaming me, police officer will not register the FIR because this is a non-cognizable offense. And instead, what police officer will do? Police officer will direct you to go to the criminal court and file a criminal complaint. What we can do for the against the patient for false complaint? So there is one provision in BNS under section 217 which says that giving false information to a public servant with to use his lawful power for injuring that person. But this offense is non-cognizable, bailable, and triable by the court of magistrate and punishable with imprisonment up to 1 year or fine up to 10,000 rupees or with both. So whenever there is a case of we defend the case of medical negligence, and during the trial, when it appears that the patient has filed the false complaint, we should insist the court to punish the patient or the complainant under this section. Hope I have delivered some useful information to you, and in this hope I end my lecture here. And in the next lecture we will talk about do's and don'ts while facing police case. Thank you very much.